Good afternoon, everyone, and welcome to today's business briefing, Labor's Industrial Relations Reforms and Your Business. My name is Tim Greenall. I'm Special Counsel in the Workplace Relations team here at Madrix Lawyers. Before I begin the presentation, I would like to also welcome those of you joining us online. So we turn to Labor's Industrial Relations Reforms and Your Business. And wasn't there a lot of talk about that pre-Christmas? Hopefully we forgot about a lot of it over a lovely break. We come back in February, first week of February, and it's still there, it hasn't gone away. So it is my job to take you through it, and certainly the purpose of the exercise are to highlight the key points for your businesses, not all the political chit-chat and all the lead-up and all the negotiating and side deals, but just what I think you'll essentially need to know in running your business through 2023 and going forward. As you probably know, the Act came into force on the 6th of December last year. There are various commencement dates, which I will be highlighting in this presentation. The key provisions, the main sections I'm going to talk about today, which are the new legislative objects, prohibiting pay secrecy clauses, prohibition of sexual harassment in the workplace, the enforceable right to request flexible work arrangements and unpaid parental leave, limiting the use of fixed-term contracts, and the big one, the big daddy, multi-employer bargaining. Now that might have been a little bit of a hodgepodge in terms of those topics, but I have gone through the Act on a number of occasions over January, and that's exactly how the Act appears. Hodgepodge sections zeroing in on these particular topics. And of course that is because this is the first tranche of wide-ranging ongoing industrial relations reform of the current Labor government. In fact, there was quite a lot of press this morning. We'll come to that at the end of the session, but what the second tranche will have in store for us later in the year. But for today, I'd very much like to focus on the key issues in this package, which is already, as I say, good law, good or otherwise. So this is an overarching thing to be aware of. The new objectives in Fair Work legislation and modern awards, you'll recall the Fair Work Act got passed in 2009, the modern award system, the National Employment Standards architecture came in 2010. This is the first substantial overview and rethink of that legislation, and it's driven by a couple of key factors. In fact, certainly this package, this tranche is driven by a couple of key objectives which are now enshrined in the legislation, as are the other things that we got used to when Fair Work first came out. So what this is about and driving it, the need to improve access to secure work across the economy, and the need to achieve gender equality in the workplace by ensuring equal remuneration for work of equal or comparable value, eliminating gender-based undervaluation of work, and providing workplace conditions that facilitate women's full economic participation. They're the very words that are used in the package. The Fair Work Commission is required to and has already been taking these matters into account when performing its functions, including when varying modern awards, which is an ongoing process, and setting minimum wages. So that's the overriding drivers of this package. So then we get into what are the key issues. And I've already had a couple of queries about this. This is already enforced for new employees, new contracts, prohibiting pay secrecy clauses. I think we all know what they are. They became quite common, quite prevalent in common law contracts, where essentially employees, as a term of the contract, are prohibited from discussing their pay or their remuneration with their colleagues, and if they were to discuss their remuneration, it's a breach of the contract of employment like any other breach, and it could be actionable. Well, having just explained that, I have to now say they're outlawed. They're not worth the paper they're written on for new contracts. For existing contracts, they're grandfathered until they're varied or you enter into a new agreement. There's a bit of doubling down. At the moment, they're of no force or effect, so we've changed our template. So a few clients have already done that. Standard review now, that one just has to go. But from 7th of June, there'll be a double down, and if you introduce it, we'll take adverse action as a result of someone trying to exercise their rights to discuss their remuneration, then that's a civil penalty provision now with, but again, no problem with your existing contracts. You just can't change them forever, that's all. So what that amounts to too is a new workplace right for employees, and it is very much for employees, to disclose or not disclose remuneration and ask any other employees, whether with the same employer or not, about their remuneration and any other terms and conditions reasonably necessary to determine remuneration outcomes. So like what annual increase, what percentage did you get, bonuses, what bonus did you get, all those sort of things, and that can now be freely talked about, and an employer can't prohibit or sanction in any way that type of discussion. And of course you will have noted, while employees have the right to ask each other, that does not require an employer to disclose remuneration of other employees, which the employer will be expected to treat as confidential and private. Okay. The prohibition on sexual harassment's not that new. You'll probably recall that the Fair Work Commission acquired a new sexual harassment stop order jurisdiction through the Morrison government, working a little bit like the anti-bullying stop orders. A no compensation jurisdiction, but you could essentially get an injunction. The sexual harassment provisions in the Fair Work Act have been rewritten from the 6th of March. There will also be pecuniary penalty provisions for an employer or an individual liable for sexual harassment, and there'll be vicarious liability for employers, which I think was the case anyway, but this spells it out. It will remain the case that the Fair Work Commission will not have power to award compensation directly, but applicants will now have 2 years to bring claims rather than the usual 28 days we're used to for unfair dismissal or adverse action claims. So it's been bulked up, is how I'd probably describe that, but it would have been remiss for me not to have at least mentioned it. There's quite a lot of sort of bolstering and tacking on to existing provisions in this package, and that's no more obvious than in the enforceable right to request flexible work arrangements. Now that came in with the Fair Work Act, that idea that an employee could request a flexible work arrangement, work from home, shorter late start, early finish, but it was only a right to request it, and an employer could decline it on reasonable business grounds, and there was no second guessing what the employer said went, essentially. Those rights that have traditionally been for carers and for people over 55 and other people with special needs, now pregnant employees and also someone that is in a situation of experiencing or their immediate family or household family and domestic violence. So in other words, a couple of new entrants that are able to avail themselves of a FWA. What's been bolstered up really though is now the employer must still respond in writing within 21 days. That's existing practice. Most of you have policies that would set that out. But now it must have been first discussed and consulted with the employee prior to refusal. And there's the expectation, in fact, there's a requirement for an employer to genuinely try and accommodate or reach agreement on a suitable, flexible work arrangement, even if it's not the one that the employee suggested. I guess good process, good policy, that probably was going on anyway, but it's now mandatory. And if the parties can't come to a compromise, the employee now has a new enforceable right of appeal to the Fair Work Commission, which will attempt to resolve what is now a dispute, primarily by conciliation, unless there are exceptional circumstances in which arbitration will apply, which of course that means the Fair Work Commission will impose upon the business its decision, and it will be an order of law. So, and to sort of give you a bit of a flavour how that could play out, and you wouldn't want it to play out, very helpfully Commissioner Johns issued a decision just earlier this year in Fife and Ambulance Victoria that involved an AMBO with caring responsibilities for 3 young children. She was on night shift, and because of her caring responsibilities, whereas the shift started at 6 p.m, she wanted hers to start at 9 p.m, And whereas it went through until 8 a.m, she wanted hers to stop at 6 a.m. And Ambulance Victoria basically said, well, no such shift exists. We don't do bespoke shifts. We've got funding, we've got arrangements, we've got protocols with the various areas and stations. The computer does not compute that particular request. Well, that wasn't good enough for Commissioner Johns. He thought that the AMBOs need to do a lot better, even if it involved in what his proposed solution, apart from the fact he thought there was just no accommodation or attempt to reach agreement. He was prepared to suggest to Ambulance Victoria that what they could actually do with the employee that had this flexible shift requirement was make her the spare. She could be the person that was the one on a mobile type shift that could backfill for all the people that apparently couldn't be accommodated when you have a two-man crew for every shift. So anyway, but the reason I've highlighted that case is that gives you a flavour, because that was an arbitrated outcome of a request for a flexible work arrangement under an enterprise agreement. In other words, under the enterprise agreement, that employee had what all employees will now have, a right to an independent adjudication of that issue. There's been apparently a little bit of uncertainty and ambiguity too. It's been existing law that employees on unpaid parental leave for the 12 months could always then request a further 12 months unpaid, and it could be refused on reasonable business grounds. What the legislation now does is it sets out the reasonable grounds an employer needs to take into account. They are actually the very same grounds that you would be used to and familiar with for the reasonable business grounds in responding to any request for a flexible work arrangement, but they have actually set it out quite specifically in the context of unpaid parental leave. The things you need to go through, which I don't propose to read out again because I think you are familiar with them. As I said, this is just set out specifically in the context of unpaid parental leave. The legislation does also highlight, though, that the specific circumstances of the business, including its size and nature, are relevant to whether the employer has reasonable business grounds to refuse a request. So if you're running a small enterprise, you don't have a lot of flexibility around your numbers, you haven't got a lot of, it's difficult to get backfilling and the like, well, that will still be a relevant consideration in a refusal on reasonable business grounds. So that's, yeah, I think that might have, when does that come in? That comes in on the 6th of June. Yes, it's pretty. I have tried to do these chronologically. So the next thing that pops up on the screen is the 6th of December. Later this year, the limited use of fixed term contracts. I think everyone was surprised when this proposal was floated, how widely these are used. I would prefer to refer to them as, and I think they're more commonly maximum term contracts. That's where you say, well, 3 years, but there's a notice provision within the 3 years. The advantage of the maximum term is that if the term comes to an end, it doesn't get renewed. There's no dismissal or termination at the initiative of the employer. Of course, if you prematurely terminate, then it's open to unfair dismissal and all the usual things. But the maximum term linked to funding, government funding or a project runs its term, there really was no termination, so sort of no employee redress or pushback. And it's a very flexible tool. So much so that the current government have thought it's being overused, and it's being used very much in terms of insecure work, is how they see it. So the new rule is that, yeah, no limited use, nothing for a maximum term which is more than the same role for 2 years or 2 consecutive contracts. So that's not related to time. You can't roll the contract over even for more than 3 months. If you get to the 3rd one, you get 1 renewal, bingo, commencing the 6th of December. What's more, the way the legislation works is that the contract's otherwise ongoing and valid. It just strikes out the termination date. So if you've got a true fixed term contract, which a true fixed term contract doesn't have a notice provision, that's why it's fixed term. That's why I recommend maximum term, because you can still have a notice provision within the 3 years or within the 2 years if it all goes pear-shaped. That becomes a contract at large without a notice period. And at that point, you're starting to get the common law employment lawyers really excited, because that means reasonable notice is right in the game. We all know about reasonable notice. If the parties don't agree, reasonable notice, what the notice period is. You can go off to the Supreme Court and get the court to tell you what reasonable notice is. Whereas the statute is rather miserly with a maximum payout of 5 weeks. At the Supreme Court, if you've got a long-standing senior key employee, you're talking 12 months. So again, fixed-term contracts are now to be treated with quite a lot of caution. But you've got, on the upside, you've got quite a bit of time to prepare for this. A couple of other sort of formalities I should deal with. As part of that package, there will be a fixed-term contract information statement in the True Fair Work information statement mould. So we'll now have the general one, we'll have one for casuals, we'll have one for fixed-term employees. So we'll all be very transparent about that. There are exceptions. The government does acknowledge that sometimes there are genuinely necessary and appropriate times for fixed-term contracts over 2 years or the third consecutive contract. The one that I would draw to your attention, which would be the most significant, I think in a sense, would be employees over the high income threshold. Your high paid executives coming to do a job or whatever, they won't get, you can do the longer term contracts for high income employees. And the other exceptions are situation specific, which you can see, and I guess a bit of case law will pass through, but I think the principles are pretty clear. I did say you get a bit of time to prepare for that. It comes into force on the 6th of December. So you've got people at the moment that are on the fixed terms, that's fine, and they run, they're not affected, it's new contracts. But once they come up, you won't have the option to do anything. You'll have to go into a permanent arrangement or come to some other accommodation. And of course, you should always include a notice provision within a contract, because on the 6th of December, that termination date is just going to disappear. It'll just be an ongoing contract. You don't do anything. So we turn to what really generated the most excitement and the most controversy, and that was multi-employer bargaining. Not something we heard a lot about before the election, but we heard a huge amount after the election. What I would like to do, I mean, it's quite complex, it's quite new, it's subtle, but it's wide-ranging, and as I said, and significant. The way the legislation handles it is that it utilises, renames and expands the existing enterprise bargaining streams, but in so doing it creates a new emphasis on multi-employer bargaining, or single interest bargaining as it's called. The terms are used interchangeably, away from what we are more familiar with, which is single enterprise bargaining. And that the three sort of streams, as I said, sort of tacking on and building on the existing regimes, which we're reasonably familiar with, take and sort of jump out in these new directions to shepherd in multi-employer bargaining as the preferred way of doing things. There's a new concept called single interest employer authorisations, which largely supplant what we're used to in single enterprise agreements, which still can exist, and there's good reason to renew our focus on those, and I'll come back to those. The second thing I just needed to say, something called supported bargaining replaces the low paid bargaining stream for childcare, aged care, disability workers. Not something I want to talk about now, other than to say it still exists, it's just got a new name, but I don't think it would be particularly relevant to this audience. It's very much driven by the Fair Work Commission to get a supported bargaining order. And I have to also mention cooperative workplace bargaining, which replaces the current multi-employer agreement stream that franchisees use where they want it, where like Subway, they want all their franchisees, they volunteer to go into it. That still exists, now called cooperative workplace bargaining stream. A lot of the problem with this new package actually was all the new vernacular and all the new jargon. Well, once you sort of unpack that, as I said, it's really a graft of what's already there, but there's a lot of new terminology which I've tried to cut through. So that continues, and of course the government does point out the cooperative workplace bargaining stream is open to small businesses. If they would like to go into a multi-employer bargaining stream or a multi-employer agreement, they can, but it's on a voluntary basis for a small business. So it's treated as an exemption. So what about multi-employer bargaining? Well, sorry, before I get to that, I will need to, and I will talk about the state of play for single enterprise agreements. Now, they were the driving force of the Fair Work bargaining structure, and before that, it really came in, Keating Felty put that new emphasis on enterprise bargaining in place of wide-ranging, centralised, award-based bargaining, put that on the road in the early 90s. So that's been a bedrock of and we had 30 to 40% of employees were covered by enterprise agreements. That was how wages were to be kept up and to be growing and to keep pace. Now it's largely falling into disrepair and disuse. We have a figure now whereas it used to be 30, 40%, now only 15% of employees are subject to enterprise agreements that are current. The preferred mode now is let your old enterprise agreement expire, because then you've got the structure, pay common law, pay wage increases by common law, otherwise you'll lose your staff, but don't get into fresh negotiations with unions with new logs of claims and all the rest of it. It's a bit of a stalemate, essentially. So what this package is designed to do is to kickstart that 15% back up to 30 and 40%, get people bargaining again. New enterprise agreements have essentially gone stale. Nothing's happening. And that's a great concern to the union movement, because that's their bread and butter, that's their work. And certainly in their world, that is how you get wages going. You're always going to get your minimum wage increases, which have been, I think it was about 6.5% last year and the year before, a bit of a pause during COVID, but where real wage growth comes is through enterprise agreements. And there's been a lot of talk about 5 plus 5 plus 5 for the next 3 years. That's how you get wages kick-started, in the words of our current Workplace Relations Minister, Tony Burke. So you only have to get into the multi-employer bargaining world, if you don't deal with your single enterprise agreement. But to kickstart that, whereas at the moment the employer completely controlled the commencement of bargaining, absent a 51% workplace determination in favour of bargaining, now the union can just trigger it by serving a notice saying you've got to bargain. You've got an enterprise agreement, or perhaps you haven't got one, but we've got members and we want to bargain a new agreement or a renewal of the existing agreement. It's not for the employer to sort of now fold up their hands and say, well, good luck with that, show us your 51%. That the piece of paper will be sufficient, provided that the proposed agreement the union want to bargain on is a single enterprise agreement that's past its nominal expiry date, which most of them out there have now. No more than 5 years has expired since the agreement expired. The proposed agreement covers the same workforce, and that they're not already in the multi-employer bargaining stream. So what is the upshot for employers given the new rules of the game in relation to their existing single enterprise agreements? Well, as I said, no need for the 51%. You can't sit on your hands any longer. And if those requirements, the requirements above are met, which is simply really like what most employers would be familiar with, the idea of serving a notice of representational rights to employees to be affected by bargaining, the union can now essentially do that to the employer. It's just a piece of paper. So employers are required then to bargain, subject to good faith bargaining obligations and protected industrial action when it gets to that, but I still think that will be fairly rare. This is more attractive than it may appear, as a single enterprise agreement in force will protect an enterprise from being roped into multi-employer bargaining. We're going to hear a lot more about roping. Roping used to refer to awards. You had to be roped to an award prior to modern awards, which apply to everyone across industry. Roping will now be about the union's got an enterprise agreement against one enterprise. What the union or that employer might want to do is then rope in its competitors in a similar position. That's what roping will now mean. We're going to hear a lot more about roping, and that's literally what it is. You can only do it through a commission order, and I'll talk about how a commission order comes about, but that was the old way with roping under award. You had to go to the commission to rope or to get an award made binding anyway. So how does roping come about? Well, the union, or note another employer, a competitor of yours, if they're going to pay over the odds, they may well want you, because their main and near competitor be paying over the odds as well. Any other conversation that could be price fixing, but not in the wage conversation. Can apply to the Fair Work Commission to require the employer to bargain with other employers on a multi-employer or single interest basis. So that's the test. So none of this, all this multi-employer bargaining occurs it's subject to the strictures of the commission. So it's not at large. It's not like a single enterprise agreement which goes on until you need to get it approved. You start at the commission, and the unions were already starting to do some of this work because this is a terrific opportunity after what they would describe as a drought. And the Fair Work Commission must grant the order if the employers have clearly identifiable common interests. These are the examples given in the legislation, which may include the nature of their enterprises and terms and conditions of employment in those enterprises, their geographical location, and where they are subject to a common regulatory regime. It's very broad. It is going to need judicial interpretation. Professor Andrew Stewart, who I think is the leading academic in the subject, expressed a lot of reservations. He said, I don't know what it means if I don't know what it means, and I do this stuff 24/7. I don't know how the man on the street's meant to know how it means, what it means. So some sort of a compromise. One of the crossbench popped up and said, yes, that is rather a bit of a problem. I think we need to introduce a further concept. So what we now have is that, plus the operations and business activities of the common interest employers as defined, and I've got that on the PowerPoint for you, are reasonably comparable. Again, no guidance on what reasonably comparable means. In other words, the commission's going to decide. We're going to go up there and we're going to have tussles, and these words are going to get interpreted. And again, no legislative guidance as to what that means. It's an extra test that's being thrown in so that really it's probably a fail-safe option if it looks like the clearly identifiable common interest test is going to go off the rails. I mean the notion that perhaps a Qantas and Virgin might have clearly identifiable common interests, but if we were to have an airline industry subject to one labour agreement, one wages agreement, the whole industry will be fixed into a cost structure which will affect everyone. So there's a bit of an out in the second clause. There are also the very broad Fair Work Commission discretionary considerations which will come into play, and there are plenty of those. So the Fair Work Commission have got to decide it's not contrary to the public interest for the common interest employers to bargain together. The Virgin Qantas example, which is taken out of thin air, does spring to mind. The broader economic ramifications of having one agreement that regulates our whole airline industry pretty well in one fell swoop springs to mind. That may not be in the public interest to have that locked in. There'd be no competition at all. Employers and unions obviously have to have an opportunity to express their views as to whether this gateway to multi-employer bargaining will be opened and authorised. Need to have union involvement so that the employees aren't led astray by multi-employer bargaining. And there are some exclusions too. If you get through all those discretions, this is probably a bit of a killing ground for sort of the work I expect to be doing over the next 12 months, how to get out of it. We don't want to do this, taking control away from us. Well, small businesses rest easy. That's fewer than 20 employees. We're all familiar with 15 employees, but the crossbench thought for the purposes of multi-employer bargaining, we need to have 20. What goes on in Canberra is quite amazing. So we've now got 20 for 15 is generally the number, but 20 that comes to multi-employer bargaining. And furthermore, an employer with under 50 employees, so a medium-sized enterprise, can make a case that it's not a common interest employer and or that its operations and activities are not reasonably comparable to the other employees it's being roped in with. The CFMEU got the thumbs down. They already do this stuff every day of the week called pattern bargaining. They didn't need this, so they're doing it out in the field every day of the week. So they're excluded. They didn't need it anyway. The employer does not consent. On multi-employer bargaining, you can vouch to actually, if the employer says no, the union's then got to go around and show that 51% of each of the enterprises to be roped want a multi-employer agreement, but given pay rises of 5 plus 5 plus 5, I don't think that will be a significant barrier to enterprises being roped to multi-employer agreements. But some of your other sort of keep safes are that you're already bargaining in relation to a single enterprise agreement, which goes back to that point. Your first point of call would still be the single enterprise agreement. But you've got to get in first. If the multi-employer bargaining thing happens first, you're too late. There's got to be a history of effective bargaining. It's got to be less than 9 months since the expiry of your last agreement. But as I said, if you've already in an agreement or you've committed in writing to bargain for a replacement agreement, you've got the antidote to the unknown world of multi-employer bargaining. So they're the new rules of the game in terms of the commencement of bargaining. The Fair Work Commission, not surprisingly, has an enhanced role in the actional bargaining process and disputes. They already have a role at the moment to issue bargaining orders if parties aren't bargaining in good faith, and there's a bit of law about that. Not a lot of law, it's been reasonably self-executing. Now they'll be empowered to resolve bargaining disputes that have gone on for a minimum period of 9 months, or at least 9 months has elapsed since the nominal expiry of the previous agreement. And they can make an intractable disputes declaration, and this is the key change and the driver of these negotiations going forward. The Fair Work Commission can arbitrate. Now that's really anathema to pure enterprise bargaining. It's something that the Fair Work Commission haven't had the power to do except with the consent of the parties. That is, impose their decision in relation to an unresolved matter after the expiration of a post-declaration negotiating period for a specified time. So that can play into either way. I mean, going back to Qantas in 2011, they actually wanted arbitration. They had an intractable bargaining dispute. They had protected industrial action. They grounded their airline, as you'll all recall, but they were quite happy to go along to arbitration because they thought they would do better in arbitration, and that proved to be the case than they were doing in their bargaining with the various unions. But the key point, the Fair Work Commission have got an enhanced role. They can impose a decision, binding decision. So again, this idea of it's about kickstarting bargaining and kickstarting wages. If you want to avoid an arbitrated decision, you bargain. The actual process itself, which I think in recent years we all would have had our frustrations with how legalistic and technical it's become. This is where you've actually got employees that have voted to approve a new agreement, and there aren't only 15% of those out there. You then had to get it past the Fair Work Commission that had to be satisfied that it had been genuinely agreed. Those very prescriptive statutory declarations that HR managers and industrial representatives had to do about the 7-day access period, the notices that went out. So from the Fair Work Commission is currently consulting about a single broad requirement to be satisfied through a statement of principles that the agreement has been genuinely agreed. So watch this space, the consultation started, but it's going to be broad principle rather than that very audit-based checking exercise. And of course, for multi-employer single interest enterprise agreements, the employer must obtain written agreement from each bargaining representative for the agreement prior to putting the vote. Again, a special requirement for multi-employer bargaining because it has much wider ramifications. Further changes too this is to make the approval process more streamlined than it has been. It has been very choked up. It does partly explain actually why enterprise bargaining has gone into disuse and disrepair. It's been technically very difficult to get your agreement approved under the better off overall or the boot test, because it became very pedantic in terms of whether you passed every line of the award. Now it's going to be a global assessment to ensure each employee is better off overall, but not a line-by-line comparison between the proposed agreement and the relevant modern award. It also, and there was a lot of hijinks with Coles and with Audi about whether every employee on penalty rates who was better off overall compared to the award. In Coles' case, it was proven they weren't necessarily. And then this whole sort of new flavour developed about hypothetical employees, and if they only worked on Saturday night and Sunday, they wouldn't be better than the award, and that was invalidating the whole agreement. So the Fair Work Commission is now directed to only consider existing patterns or kinds of work or types of employment that are reasonably foreseeable rather than hypothetical possibilities as currently happens. So a little bit legalistic is the idea. But what the Act giveth, the Act taketh. So you might get a bit more certainty in that regard, but where the new uncertainty is the agreement can now be reassessed against the boot after it's been approved, which that was not a possibility prior. If relevant circumstances were not properly considered, or like shift changes came into place in the light of the agreement, and for the agreement to be amended, including with retrospective effect. And the Fair Work Commission can make the amendment of its own volition where it is necessary to comply with the boot. So enterprise agreements will still be something that requires a lot of focus on detail. And the last significant topic I wish to deal with in terms of trying to take you through what I think are the key drivers for your business of the new package, which is largely enforced. Well, I have got clients with these. The zombie agreements are agreements that were actually made prior to the commencement of the the Fair Work Act back in 2010, but they were transitioned. They were transition grandfathered on the basis they had been agreed in good faith under the old laws. And as I said, you could just keep using it. Of course, you obviously had to update the pay and you had to apply the NES, but they were still the institutional framework for your bargaining. And now they've got a sunset date. They've got to expire. They come to an end. They're void from the 6th of December 2023, and employers have to give 6 months' notice to all affected employees. If no new agreement is entered into by that date, then award conditions will apply to employees. And as I said, I've got a couple of clients that will have to get a bit of a rattle on, but they also see it as an opportunity to bring their workplace relations into this century. Furthermore, the termination of other enterprise agreements, they're not the zombie agreements, just any agreement which have expired on their nominal expiry date are now subject to much more stringent requirements with contested applications. This is where an employer, universities used it quite a lot, where they couldn't negotiate a new agreement. They wanted their existing agreement terminated. The unions regarded it as a tactic. They were able to persuade the government it was being used as a tactic, and it's now going to be much harder for employers to terminate agreements that, as I said, have expired, but the structure's still there. So, but I needed to mention it, but I don't think it has widespread relevance in the sense that it tends to be the very big employers, universities and the like, that will go to that type of trouble and expense to get rid of an existing agreement because you need a commission order. It's quite a big exercise to do it. So for those employers that have enjoyed not being part of the enterprise bargaining system, and my advice for some years has now been, why do it? Why would you open it up to yourself? If you don't need to do it, don't do it. If you don't understand it, certainly don't do it. That will probably no longer be a viable commercial choice, particularly if you want to stave off, and you probably do want to stave off the weird and wacky world of multi-employer bargaining, which we'll all have to learn a lot about very quickly. So we have, we've got 20 minutes remaining, so I can take a few questions. For everyone online, please feel free to submit them via the chat panel. Thank you for your attention.
I can't see behind me. I have a couple of questions that came through online. Could any of the reforms change again? Any of these reforms change again as a result of the second tranche of workplace reforms expected later this year?
Yeah, so I'll just perhaps restate the question a little bit, will I, please. For the benefit of people. I've just been asked, the second tranche, the Minister for Industrial Relations, Tony Burke, was at the National Press Club yesterday. He confirmed that this is just the first tranche. There's a second tranche of IR reform that will be introduced into Parliament in the second half of this year to deal with some of the issues that we were actually told about before the election, like definition of casual, same job, same pay, gig economy, wage theft. So those things I think are distinct issues to the discrete issues that were dealt with in this package. So I think this package may well be amended, but it won't be through crossfire from the second tranche. This stands on its own feet. It may well have to be tweaked. It is to be reviewed in a couple of years. That was the crossbench amendment. But I think this sits as it is, and then there'll be another tranche that maybe I'll be able to bring you all back in towards the end of the year. So, but that deals with different topics we're more familiar with.
On to the next question. Does the change legislation risk inflation or wage inflation that increases costs without any productivity improvements?
Well, I think the whole driver of this is to get wages up. I think in fairness to the government, they've been unabashed about that. And of course, it's going to drive wage increases. It's designed to do it. And bargaining enterprise agreements, they are the channel or the stream, because we've got minimum wage increases through the national wage case every year anyway. But enterprise agreements are there to turbocharge wages. And even the fact that this is on the table now, that must be sort of the message or the mantra from me today. It's on the table. Even if you don't fully engage, all these forces and new influences are out there now to get bargaining and get wages moving. So we would hope it won't be overly inflationary, but the productivity trade-off, that's not what multi-employer bargaining is about. That's what single enterprise bargaining is meant to be driven by. Hasn't been as effective in recent years as it was when it first got brought in, and that it was harder to actually get productivity set-offs, hence the dying use of enterprise agreements. So I think it's a watch this space, but in terms of the way the legislation's been put together, there's a lot about wage increases and very little about productivity.
One more question from online, which is, does this make it easier for employers to pay staff or more complex?
Well, I think the bargaining process is reasonably complex because we've got to get our head around. I've got to say too, when I was watching the debate before Christmas and we're all busy and it was all swirling around, the headlines were entertaining and interesting, but it wasn't until you actually sit down with the legislation and try to come to terms with the new technical terminology and the way it's put together, the way that this multi-enterprise bargaining is a new concept for us. It's sort of a new influence, a new pillar in our wage regulatory structure. So there's more complexity in the system in terms of actual wage outcomes. Well, you've got your rewards still, you've got your minimum rates, you've got your contracts. I think that the complexity is more in the bargaining process than the actual payment of wages.
Thank you. I have no other online questions.
Sure.
Tim.
Yes, Rick.
The pay secrecy clause prohibition, just thinking about the sort of practical implementation of that in terms of drafting of contracts. I mean, an employment contract, I understand, would typically have your standard confidential information, confidentiality clause, which might define confidential information in fairly broad terms to cover all information related to the business. So on its face, it would provide that pay is part of confidential information, and then it might have a proviso that you're not restricted from disclosing confidential information if you're required to do so by law. Now, the law doesn't actually require you to disclose it. It just says it's a prohibition to include a clause to restrict it. So, I mean, have you thought about how you would be redrafting clauses to get around this? Would it be something as simple as just in your standard confidentiality clause to say that there's no prohibition against discussing your own or disclosing your own pay? Is that?
Well, yeah, I'm a simple workplace lawyer and I don't draft super complex confidentiality clauses like you will draft, Rick, and we're pleased to have them too, I hasten to add. But in employment law terms, that there are very specific pay secrecy clauses which we will no longer be able to draft. But in terms of your more interesting point about confidentiality clauses, which define confidential information very broadly, they'll either have to be read down so the employee would still, or they have to be read down so they're not invalid. And to the extent that that they're invalid, we'll have to hope they can be severed, because you'll have a severance clause as well, Rick. But I do think that they will have to be read down or severed, otherwise the whole clause will be invalidated, and that would be unfortunate. Yeah, because the statute will override something that really, you can't do it sort of directly or in the front door. You won't be able to use a backdoor confidential information clause to achieve the same thing, even though it would be capable in the way you describe it of applying. So there's a little bit of work for commercial and workplace lawyers.
Thank you.
My question was far less technical. The 555, can you just take me back? Is that an actual thing? Everyone's getting 555%?
Oh no, that's just, but that just seems to be around what I'm reading in the press. They're the sort of deals that are being, yeah, exactly. That's enterprise. As distinct to the sort of 5.6% at national wage case, the way enterprise agreements tend to work is, 555 next 3 years, you lock it in. So, and that seems to be about where it's at in terms of log of claims, real negotiations that, from what I'm reading in the press, are already going on, because you're better to do a single enterprise agreement and know about your 555 than get him roped into something that you knew didn't see coming.
Can I ask him, with employers that say have under 200 FTE, but they're in a sector with competitors that have collective agreements and enterprise bargaining, but they're on common law contracts, what do you see as, I suppose, as the potential impact to the smaller businesses in sectors that predominantly have enterprise bargaining and collective agreements in place? Because I'm gathering this will impact potentially those employers.
Yeah, I think the risk is for the employers in sectors where there are enterprise agreements in place, but they're not in their own enterprise agreement themselves for their enterprise, but their competitors are. So that is an easy roping exercise. That's the sort of thing I think they're interested in getting going, if I've understood your question correctly.
Yeah, because I'm just sort of thinking we're in obviously aviation as a SME player next to the likes of, Boeing, that is hugely in collective agreements and enterprise bargaining.
Exactly, and they have no choice and they're locked in.
And from a talent comparison.
Yep.
Yeah.
So that's where the smaller enterprise in that complex and fairly large employer-based industry will need to make a case that it's not reasonably comparable. There is a common interest. You're in aviation, these are your competitors, but what we're doing and what you're seeking to make us bound to, which we didn't negotiate, is not reasonably comparable. And perhaps in that sense, the fail-safe test will be useful. So yeah, the risk is with the organisations that aren't in the existing structure.
Can I just ask a question of clarification on the fixed term contracts? I understand it's no more than 2 contracts for 2 years. If we currently have staff on a fixed term contract that we're going to renew, theoretically it's their second contract after this. Does that become their second, or is it their first under this new? No,
it becomes their second. It's a consecutive contract. It's a good trick question. I had to get my head around that too. It's not the 2 years. It's actually and of course it's not meant to be retrospective, but your first contract's rolling and running while we're talking.
Correct.
Yeah.
Excuse me, Tim. Just in relation to a client who's got an enterprise bargaining agreement in place now, expiry date, I'm not quite sure what it is. What would their approach be?
Well, it's actually one of the 15%, are they, that actually have got, it hasn't even expired. Well, they're protected, they're safe, they're doing what the current government would like them to be doing, so they get a tick, they get a credit for that. It's just that when it expires, they will want to roll into the new agreement within 9 months.
Good.
Okay,
Yeah.
good. All right, well, it's been very nice to have everyone along, a bit like the old days. I hope to see you later in the year with the second tranche. Good afternoon.
Thank you.